So let's jump right in. The agenda to cover today, we'll talk about enforcement trends, specifically looking at security incidents and breaches, as well to what we're seeing from a right to access standpoint. We'll spend a little bit of time discussing breach and incident response, and then finish up with a discussion of the notice of proposed rulemaking that was issued earlier this year, and to highlight some proposed changes to the HIPAA privacy rule if this proposed rulemaking is actually finalized at some point. So let's start with enforcement trends. If you guys, many of you have attended Health Law Institute before, I like statistics. And so here on this first slide, just kind of captures what's been going on from an enforcement standpoint in the last 3 years. You'll notice 2018, lots of actions, lots of settlements, record year really for the Office for Civil Rights and its enforcement activities. In 2019, we sort of saw a lull, fewer actions, fewer settlements. In 2020, even though we were in the midst of the COVID pandemic, OCR managed to investigate and settle 15 actions with settlements totaling $13.5 million. And where we're at in 2021, so far, 9 actions have been settled, but the enforcement settlement amounts have only been $5.65 million. And you'll note as we go through 2 specific cases related to security incidents in the next couple slides, Excellus Health Plan is a big portion of that 5.65 million, with its settlement being 5.1 million. The other notable for 2021, and we'll spend some time talking about that today, is the role of OCR's enforcement in these right to access cases, and what providers need to know about that, and how that's kind of playing in the overall enforcement scheme and settlement amounts. So the first case is the Excellus Health Plan case, and this was settled earlier this year. Excellus is a health plan based in Rochester, New York. The breach dated back to 2013. It wasn't discovered until 2015, and as part of the investigation, OCR determined that hackers actually got into the system in 2013, installed malware, and conducted reconnaissance activities over a 17-month period. During that time, they had access to Social Security numbers, dates of birth, bank account information, detailed information related to clinical treatment and claims data, and for over 9.3 million individuals that were participating in the Excellus plan. As part of the investigation, OCR concluded that Excellus had failed to comply with the HIPAA security rule in a number of instances, including a failure to conduct an enterprise-wide risk analysis. And you'll note time and time again, in these security incident and breach enforcement cases, this is a common theme, the failure to have that enterprise-wide risk analysis. They also failed to implement risk management and information system activity review and access controls. It really troubled the OCR the fact that these hackers were in their system for 17 months. And to the point that the then acting OCR director, when they announced this settlement earlier this year, stated, in this case, a health plan did not stop hackers from roaming inside its health record system undetected for over a year, which endangered the privacy of millions of its beneficiaries. And OCR really felt strongly about the fact that it took them 17 months, and had they had some information system activity review, auditing of access controls, they would have been able to identify the hackers in their system much sooner. As I mentioned before, they settled for $5.1 million. They're under a 2-year corrective action plan, which included performing a full risk analysis, developing a risk management plan, developing and distributing HIPAA security policies and procedures, and importantly, completing an electronic protected health information inventory, which is something, and Amanda and I, train providers with respect to HIPAA. I mean, that's certainly something that we recommend, regardless of whether you're under a corrective action plan with OCR, you hope you never get there. And one way not to get there is to actually have a complete inventory of every place your protected health information is, whether it's in paper or electronic format. Having that inventory, it's not just your electronic health record, it's every piece of equipment that can store protected health information. It's your portable ultrasounds, it's your CT scanner, it's your MRI. So that's a really good, I think, takeaway from this particular corrective action plan for you to take back to your organizations, is to make sure you have that inventory of where your protected health information and your EPHI is located. The other security incident breach enforcement case from this year that I want to discuss is the Peach State Health Management case. And this was actually a diagnostic and laboratory testing lab. And what's interesting here is this wasn't, this enforcement action did not come out of a reported breach situation. This was an OCR initiated compliance review. And under the HIPAA regulations, OCR does have the authority to do compliance reviews, in the sense that it reaches out to a provider and says, we want to take a closer look at your HIPAA privacy and security compliance. And Peach State was just unlucky here. OCR doesn't do a lot of compliance reviews. And in this case, Peach State was selected for a compliance review. And it was really an overall review of their privacy and security compliance. And similar to what we discussed with Excelis, they were they were found to have some non-compliance with respect to the failure to conduct an enterprise-wide risk analysis. They didn't have effective risk management or audit controls in place, and they did not effectively maintain documentation with respect to their HIPAA security rules, policies, and procedures. It was a lot of we informal, unwritten, this is what our process is, but there wasn't anything written down. Relatively low dollar settlement here, and I think that it's based on the fact that this is a smaller provider, and OCR has said time and time again that when they are assessing a settlement to resolve a case, they do look at the size of the provider, the financial resources that the provider has. But what's interesting is, as part of their corrective action plan, they're actually under a 3-year monitoring plan with OCR, which anybody that's had to go through a corrective action plan with any government agency, it's not fun to be under the lens of the regulatory agency for 1 year yet, let alone 3 years. So here they're going to be scrutinized by OCR for a 3-year period to make sure they get their compliance up to date. Now I want to talk about the right to access cases, because we're really, most of the enforcement action, aside from the 2 cases I just discussed, has really been focused on the right to access. And those of you who attended the Health Law Institute in 2019, you'll recall that I spent some time talking about OCR's new initiative, their Right of Access initiative. And so this started at about 2 years ago in September 2019. And OCR stated purpose for this initiative was to support vigorous enforcement of a patient's right to receive copies of records promptly and without being overly overcharged. Since then, there have been 20 settlements. So in that 2-year period, there's been 20 settlements, 7 in 2021 alone, and we still got 2.5 months to the end of the year. What's interesting is that the settlement amount, with respect to 2021 is only around $1 million. Or total for the 20 cases is only around $1 million. So we're seeing in these right to access cases, there's more of them, but the settlement amount is less, and we'll have to kind of stay tuned to see if that pattern continues. But now I want to just walk you through the right to access cases from this year and highlight just a couple things to have on your radar when you're educating your HIM, your medical records staff, on responding to these requests for access. So the first case involved 2 patients, each filing a claim. This was a traditional patient request for access to their protected health information. They weren't asking for anything that would be considered sensitive, or anything that wasn't part of the designated record set. It was just 2 patients made separate requests to gain access to their protected health information, and they were denied. And this was the first case of the year, so as part of that, The acting director made clear in his public statement that the first resolution of the year signals that our right of access initiative is still ongoing, strong, and that providers all sizes need to respect the rights of patients to have timely access to the records. So he was sending a message that this continues to be, I think to me, I interpret it to be a passion project for OCR, and as it's played out in the rest of this year, we've seen additional cases. The next two cases demonstrate what can go wrong when a patient or a personal representative says, I want my protected health information to be sent to a third party. That could be a law firm, that could be their next door neighbor, that could be their spouse, that could be their companion. But it's a situation where the patient isn't wanting the access. They want the provider to send the records or provide access to a third party. In both cases, it was a situation the patient made the request. Again, there was nothing wrong with respect to the request. It was all information that the patient would be entitled to. But for whatever reason, the provider just failed to provide that access. And what was particularly stark in the Sharp case is that it took multiple complaints from the same patient. Even after OCR got the first complaint and educated Sharp Healthcare by providing technical assistance to say, these are the requirements under the right to access. The patient has the right to ask you to send their information to a third party. Sharp still didn't get the message, and it took a second complaint filed by the patient before that information was sent to the third party. In Arbor Hospital, the same type of scenario, again, with respect to a patient asking for information and the OCR taking the step to provide the technical assistance. Arbor still not getting the message and taking a second complaint by the patient to get their protected health information sent. And so really, from the time the patient made the request to the time they actually got the records, it was about a 5 or 6 month period. I think another interesting thing about these right to access cases is that OCR seems to jump on them immediately to get involved, whereas when we were talking about the Excelis case, we were talking about a breach that happened in 2013 that was identified in 2015, and they just got around to settling. In these cases, in these right to access cases, for example, with the Arbor Hospital case, the patient made the request in May of 2019. If the complaint was filed in July 2019, and OCR immediately got involved and sent that OCR technical assistant in July. So these are things that OCR doesn't sit on. They're immediately going to get involved. The 18th case, the Village Plastic Surgery case, is interesting. It's the same factual scenario, patient wanting access to their protected health information, but not getting it. What's the interesting piece is that in the prior examples, OCR provided technical assistance. They gave the provider an opportunity to self-correct before a settlement, a penalty was assessed. In Village Plastic Surgery, we saw that OCR went straight to, we're going to settle this, we're going to resolve this, and we're assessing you with the $30,000 payment in order to resolve it. So not sure if this is some sort of signal from OCR that they feel like we've done what we need to from an OCR technical assistance standpoint, that providers know that patients have a right to access, and whether they're moving away from giving providers the opportunity to self-correct. But that's just kind of something to keep in mind. In this situation, you might not have an opportunity to fix the problem before you're assessed a penalty. The next two examples, the cases 19 and 20, deal with a parent trying to get access to a minor's records. And in both cases, again, this is not a situation where the parent's trying to get information that's considered sensitive or that the minor under state law is permitted to consent for treatment, so the parent wouldn't be entitled to get access to the records. It's just your typical parent, I'm trying to get access to my records. And in both cases, well, in the first case, the diabetes center just wouldn't give the parent access. In the second case, Children's Hospital Medical Center Some records were provided, but not all of the records. And that's what that led to the settlement in that case of $80,000. So the lessons I think we can take away from these right to access cases, and I hope this is one of those takeaway slides that you can take back to your organization, is that covered entities, and if your business associates are the ones that are responsible for responding to these patient requests for access, you can't ignore the privacy rule requirements to grant a patient access. You don't get to pick and choose what records they get access to. They have a right under the HIPAA privacy rule, and OCR is out there enforcing this every day. If you don't, you may face a penalty, and I say a big penalty. And yes, we're seeing penalties of a lower denomination than we see with the breach cases, but $30,000 is still significant, especially for a small provider. $50,000 is significant. $80,000 is significant. The other thing we know from these cases that entity size does not matter. You'll note just on those 5 examples that I went through, we had diabetes, small diabetes centers, we had hospitals, we had health systems, all kinds of provider types. You're not spared if you are a small provider. Patients and family members are increasingly reporting these things to OCR. It's interesting in most of these cases, the patients didn't wait 6 months. They didn't make a request in May and then wait until November to make a complaint to OCR. They made their request for records in May, and when they didn't have them in June or July, they were making a report to OCR. So patients are becoming more educated on their rights under the HIPAA, and they're not afraid to get OCR involved. And so we need to be wary of that. It's as I mentioned, it's not up to the covered entity to decide what records a patient should have access to. Obviously we have a few exceptions, that the provider believes that releasing those records would potentially be detrimental to the patient, psychotherapy notes and those types of exceptions. But by and large, if a patient says, I want all my records, we need to give them all their records, and we need to make sure we're looking and pulling those records from all sources, not just going to the EMR. We've got, we need to make sure if we've got protected health information in other places that we are finding that information and complying with the request. As I mentioned before, with the 18th case, there was no technical assistance provided before moving to settlement. So, just kind of remains to be seen if OCR is signaling something here to say, we're not going to give you a chance to self-correct. We want to send a message. You violate the right to access. We're going to assess the settlement so that we can educate all providers that this is an important initiative for OCR. And if you look at all 20 cases we're seeing with respect to mental health and smaller providers, they seem to be less compliant than the larger health systems. So, and in part, that's, with smaller providers, you may not have a designated HIPAA privacy officer. You have fewer resources. But as I said before, entity size just doesn't matter. So if you're a small provider, you need to be compliant and be educating and training your workforce so that they understand. And the last item I propose here is OCR sending a message, and I think that's definitely the case. If you look at the cases as a whole, you look at the public statements coming from OCR, and it seems like they're kind of going from the let's nail a few providers and get a hefty penalty to let's go after multiple providers and maybe have a lower fine. And in that way, you were expanding our enforcement to include more providers under that. So some takeaways: consider strengthening your right of access procedures. So make access a priority. You need to make sure your workforce is taking it seriously and making sure that procedures are in place to accurately review the request for access and to respond and provide the information. To the extent you can, have your privacy officer or some other administrative person who's involved in implementing the right to access procedures and educating your HIM and medical records staff to make sure they understand the importance and it being critical that we comply with HIPAA's right to access requirements. Train and retrain staff members on privacy and access procedures. They need to understand that they are the professionals, they are the ones responding to requests, but patients don't necessarily understand all the forms. And we need to make sure that HIM's view of the world on what should be produced is matching up with what the patient is asking for. Otherwise, we run the risk of getting potential complaints filed against the organization. And as I mentioned before, have that inventory, make sure you know, and your HIM staff know, importantly, where all protected health information is stored. I had a situation with a provider where, radiology images were stored somewhere separately. HIM didn't interpret a request for all health information to include the images, which resulted in a complaint filed with OCR that we had to work through. So, making sure that your HIM people know where things are stored, and if they have questions, ask the patient. When you say all medical records, does that really mean that you want 5,000 pages of medical records, including every X-ray you've ever had? Or, are you wanting the last year's? Have them engage in a dialogue to make sure they're producing the records that the patient wants. And importantly, make sure staff are responding to the request in a timely fashion. Currently under HIPAA, we've got 30 days to respond. But Amanda and I always counsel our clients, don't wait to the 30th day. And if you match that up with the information blocking rule, even though there's not a specific time frame, days designated in the information blocking rule, you do have an obligation to produce that information in a reasonable amount of time. So the important thing is to respond as quickly as you can to those requests. Now I want to talk a little bit about breach and incident response with COVID. Certainly the number of breach incidents, and certainly not just focused on healthcare, but just organizations and entities as a whole. There's been an increase in security threats and incidents and ransomware. Earlier this year, the White House issued a memo providing guidance to basically, all organizations, industries on how to protect against ransomware. In July, they launched a website that's got a lot of helpful information with respect to ransomware, so best practices to try to hopefully avoid a ransomware event, checklist, and also what to do if you do get hit by a ransomware event. And that's what I'm going to kind of walk you through this morning, is just some steps to take if you happen to be a victim of a ransomware event. So detection and analysis is kind of where you start from when you have a situation where you have malware, ransomware, hacker type event. Obviously you have to determine which systems are impacted and immediately isolate them. If you are unable to disconnect devices from the network, just power them down to contain the situation. You're going to need to triage your impacted systems for recovery and restoration. This involves prioritizing those critical systems. Obviously, the ability to deliver healthcare, so your medical record is going to be critical. Probably your financial, your accounting, your ability to bill, those are going to be more critical than some of the other pieces in your system. You'll need to have your incident response team develop and document an initial understanding of what concurred kind of based on the initial analysis, and engage the internal team and use those external resources. You may need to rely on external IT support, forensics services to help mitigate, respond to, and recover from the incident. Containment and eradication, once you've done the first step on the detection, then you want to contain it and get rid of it. And so part of this, and it's in a lot of cases, you do work with that external resource, the IT vendor or the forensics consultant, because they can help take an image of your system and kind of capture all of the potential affected devices, the workstations and servers, as you're working through the containment process. Also need to collect relevant information, logs, other indicators of compromise, IP addresses, suspicious registry industries, or other files to again, part of this whole containment and eradication piece. Sometimes it's helpful if you reach out to federal law enforcement to share what kind of variant you think it is. They may have a potential decryptor that you could utilize to restore your information. And then the last point is really important. Research trusted guidance. So this could be stuff from NIST. This could be other government resources. your reputable security vendors. Use trusted guidance related to the particular variant that may be on your network, and follow any of those additional recommended steps to help identify and contain the situation. More on containment and eradication. Identifying all those systems and accounts. Don't forget about email. Sometimes email is the way the penetrator gets into your system, but then it just goes from there and spreads out throughout your network. So don't forget about your emails. Remember to contain associated systems that may be used for further or continued unauthorized access. In this situation, breaches often involve mass credential exfiltration. So securing your network and other information sources from continued credential-based unauthorized access will be key. So that may involve disabling your VPN or your remote access into your network until you get everything contained and eradicated. Conduct an examination of existing organizational detection and prevention systems. Will be part of this containment and eradication process. That means looking at your antivirus, making sure that's up to date. Is everything current with respect to your intrusion prevention system, et cetera. Conduct an extensive analysis to identify outside in and inside out persistent mechanisms. So this can include situations where somebody's on your system and looking to remove them from the system. Have they planted malware, like in the Excelis case, on your network, those types of things to get them removed from the system. And then lastly, you're going to be rebuilding systems, again, kind of based on that prioritization of critical services. After you get through the immediate detection and eradication and containment stage, you've got the recovery and the post-incident activity. This is kind of the post-mortem after the incident. You get everything reconnected, you've restored all your data, you prioritized, got your critical services back online. What do you do next? And in any type of situation, we encourage you to do post-mortem in the sense that you're looking for lessons learned from the incident and how your response activities worked. One question to ask, was your security risk assessment up to date at the time you had the breach? Did you have a new piece of equipment? Did you do something, add a server? Did you change your EMR? And were those potential vulnerabilities that those updates or upgrades may have caused, were those taken into account? Don't forget that you can have access to the risk assessment tool that on the healthit.gov website, and I've included the link here in the presentation materials. It's a really good resource for any type of provider that it walks you through. You download the tool, it asks you a bunch of questions, and it's a good way to conduct that security risk assessment that you need to evaluate and identify potential vulnerabilities within your system. The other piece that can be important from a lessons learned standpoint, oftentimes we see old devices, things that are out of date. Maybe the software is out of date, the security updates, or there's no longer any security updates. Sometimes those can be vulnerabilities that allow the penetrator to get into the system. Impersonation, we see this a lot with the phishing emails, where you get an email and it looks like it's from an employee internal to your organization, but if you actually look at the email address, you'll see that there's something different. Maybe the name is spelled differently, or it's full first and last name, and your organization uses first initial and last name. So really be careful with respect to those emails and looking at those carefully. And then the other piece can be to bring your own devices. If you allow your staff to bring their own devices where they access your EMR, they're using that for email and other types of communications, and you don't know, do they have encryption on it? You don't know if they have appropriate apps that would protect the data. That can be another potential vulnerability. So some takeaways, additional takeaways to keep in mind with respect to incident response. Don't wait until you have a security incident or you have a breach. Make sure you put your team together now. Make sure you test your incident response plan periodically. That could be a tabletop review exercise where you just kind of sit around a round table and you have a hypothetical situation. Oh, and this is a good reminder for everyone that's listening to this section. You should have received a question, the polling question number 2. If you're still watching, please make sure you click on that. If you did not receive the polling question, you can also type in the code on this slide into the chat so we can make sure you get credit. You can also do planned incidents where it's actually a more simulated, so it's not on paper that you could, and typically you have to work with an outside IT professional in order to do that. But you could actually, if you really wanted to work a potential, in real time live, what would you do? You can do a simulated planned incident. Make sure you're training your employees about the phishing emails, the impersonation, email attachments. If you're not expecting to get an email from someone, don't just click on the attachment. Be careful. I notice when I use my iPhone email, it's harder to catch those impersonation emails than if I'm on my desktop. So just train that they understand that. Just don't click on things. Encourage them to use strong passwords. Update your policies and procedures on incident response and mitigation to the extent you don't have them up to date, and make sure that security risk assessment is up to date. For the next 12 minutes or so, I want to talk about the proposed rulemaking issued earlier this year. So this was published in the Federal Register in January, and so these are proposed modifications to the HIPAA privacy rule. The comment period was initially through March, and it was subsequently extended to early May. And I've got a link to it here on the slide if you want to go and take a closer look or read it cover to cover to see what might be coming down the pipeline. I will tell you that although it was published in January, it was actually issued in December, so it was under the Trump administration. So it kind of remains to be seen if any of this will actually be finalized, but there are some positive things that could come out of this, and then there are other things that has gotten a lot of blowback from providers. But so there's a couple definitions that HHS has proposed as part of this rulemaking. One is for electronic health record, and I think this is in part a reaction to the information blocking rule and the definition of electronic health information we have there. But it's again trying to kind of, I think, expand on the concepts that we're seeing with the information blocking ruling and making it clear that it's any type of health information that's created, gathered, managed, or consulted by and used by healthcare providers in delivering care. And it also is clarifying that it includes individually identifiable health information as defined under the HIPAA privacy rules. That next definition relates to personal health applications. And again, I think this is kind of tracking with what we're seeing under the information blocking rule, with the articulated ability for patients to ask for information to be sent to them via personal health applications. And so this is, I think, HIPAA's attempt to be brought in line with what we're seeing under information blocking. And is this kind of a definition that tracks pretty closely with what we're seeing with respect to the information blocking rule. With respect to right to access, given OCR's heavy enforcement of right to access, it's not a surprise that they feel like they need to revise the HIPAA privacy rules to strengthen and perhaps expand an individual's right to access. So here we've got a couple interesting things. First, it's the allowance that the individual, so the patient, can actually take notes, photos, videos, during their encounter and ask for those to be included in the designated record set. And so you'd expect a lot of negative comments from providers on allowing patients to take notes, photos, and videos, and have them, demand that they be included in the designated record set. So we'll see if this one actually gets adopted or not. I mean, there's all kinds of risks, I think, associated with relying on patients to take notes or photos. They may not be good quality. We may not agree with what the notes are. Now we're putting them in our designated record set. The other interesting piece relates to providing access to PHI when it's readily available at the point of care. So that means if a patient wants to take a look at their lab results, this conceivably means if the provider could pull them up on the EMR while they were sitting next to the patient in the room, that would be considered readily available, and the provider would need to do that, as opposed to saying, well, you need to go to our medical records department to get that information, or you can access that through the patient portal. If it's readily available, if this is adopted, then the provider would need to provide that access at the point of care. Modifies implementation requirements. I think a lot of this will look familiar to those that are familiar with the frequently asked questions that OCR issued in 2016. This kind of ties into Clayton's discussion during our last presentation related to the issue with rulemaking. There was some litigation around the 2016 frequently asked questions in the sense that they didn't go through the formal notice and rulemaking process. I think this is OCR's, HHS's attempt to get what it wanted accomplished via 2016 as part of its regulations, so that we see this emphasis on not creating barriers to access. So for those of you providers that like to use an access request form, and that is okay as long as you're not requiring patients to complete a full-blown HIPAA authorization, and you're not requiring them to complete that access form if they're just unable to do so. So if it would slow or impede their access, you can't have them complete the access form. And typically what Amanda and I encourage providers to do is you just have your staff complete the access form, so you have a record of what the patient requested, how you delivered it to them, the format they wanted, and the like. Response time. This proposed change would take the 30 days down to 15 calendar days, including a one-time 15-day extension. Again, I think this is an attempt by CMS to kind of get the response time under HIPAA more in line with the response time under information blocking rule. As I mentioned before, we don't have a set designated number of days under the information blocking rule, but there's this reasonableness that you need to produce it as quickly as you can. And I think that this is just CMS's response to that, to try to get the two more aligned and to make it easier for providers to comply with both. I think what I found interesting about reading the rule is this next bullet is that they're talking about taking it from 30 to 15, but also an obligation for providers to develop policies and procedures to prioritize urgent and other high priority access requests. So that there's a provision, if it's high priority, they're hopeful that you would never even need to do a 15-day extension because you're going to respond to those first. And the response time, they're clarifying the response time applies to an individual or personal representative request, or if the individual requests that you send the information to another third party. Fees, I think this is another area where we're seeing, this was also addressed in the 2016 frequently asked questions, and I think they're trying to get most of this into the regulations, although there are some nuances. So on this first slide, it talks about a situation where somebody's not asking for a copy, but they're just asking to inspect. This hasn't changed from the privacy rule in the sense that they're just clarifying that if somebody wants to show up and look at their record, they don't want a copy, you can't charge them for that. You can't charge them to use the patient portal. This next slide talks about other ways to access the information, and it's described as an internet-based method. So this would be personal health application would be an example of that. And again, it's a tool, a way for them to access the information. So you can't charge them for accessing their information through a personal health application. This next slide talks about a situation where the patient's requesting a copy in a non-electronic copy of their PHI. And so this doesn't change. So this is your standard. You think about it, a patient walks in and wants a paper copy of their records. This isn't changing. We're still under the reasonable cost-based fee that's currently defined in the privacy rule. So you can charge for your labor, supplies, postage, for making that paper copy. Where we're seeing a little bit of a change from the 2016 frequently asked questions to what they're proposing to put in the regulations relates to the electronic copy. And what they're stating on the electronic copy is that under the 2016 questions, you could also charge for the media and postage. So if they wanted you to put it on a CD and mail it to them, you could charge for those things. And what this rule is making explicit is that if it's an electronic copy, you can only charge a reasonable cost-based fee for the labor for making the copy, and you can't charge for any of the supplies or CDs or any of that. Third-party fee structure. This is when an individual wants to direct to a third party. Basically, the same rules are going to apply with respect to electronic copies. So it's the same reasonable cost-based fee if the patient asks for the electronic copy to be sent to a third party. If it's an individual directs a non-electronic, so a paper copy to a third party, then the reasonable fee limitations, they're not subject to that. So that's kind of an interesting, I'm not really sure why they chose to distinguish it in that way, but that's what they're proposing to do. Some other interesting things to keep in mind with respect to fees if this is adopted. The rule would require covered entities to post their fee schedules on their websites, provide a copy of the fee schedule to the individual upon request, provide individual estimates of fees and the actual cost for making the copies. And then the last point I think is important, that you're still able to charge up, require payment up front before sending the copies. So especially on those large requests where it may be hundreds or thousands of pages of records, you will still be able to charge up front so that you're not in a position where you're having to eat a lot of cost for those big requests. Identity verification. This was a concept we saw in the frequently asked questions. It is permitted that you do some sort of identity verification as long as it's not a barrier. It has to be reasonable for the circumstances, and it expressed in the rule. Two specific things would be prohibited: requiring a notarized signature from the individual before you would release the records, or requiring in-proof identification when a remote method could be used. So you have a situation where a patient calls up on the telephone and says, I need a copy of my medical records faxed. It would be a barrier unreasonable in order requiring them to show up and provide a driver's license to confirm their identity, when there are other ways you could do it over the phone by asking them social security number, date of birth, when was your last appointment with us, other types of information that could be used to verify they are in fact who they say they are. Notice of privacy practices. This one I think would be a win potentially for providers. They're proposing to eliminate the requirement that we obtain those written acknowledgement of receipts of notice of privacy practices. I think they've realized that, after 18 years of collecting those, that that there's really not a need to do that anymore. But the second bullet, they're proposing to replace the written acknowledgement with the individual's right to discuss the notice of privacy practices with designated person. So the feedback and the comments from providers is, well, yeah, we love the fact that we're not going to have to get this acknowledgement, but to have to designate a person in our organization to talk to people about notice of privacy practices is just too burdensome, isn't going to work. So we'll have to see how that one comes out. Also importantly, proposing to eliminate the need to retain your notice of privacy practices for 6 years. So right now, every time you update it, we tell you got to keep it for 6 years. If this is adopted, you wouldn't have to retain them. And there will be some slight modifications to the notice of privacy practices. They're proposing to modify the header that we use on our notice of privacy practices, and of course, going back to right to access, that individual right. More requirements to explain and highlight individuals' right to access information. So with that, I've concluded our second session of the morning.